All right, thanks for taking a look at this. I'm John Fulweiler, and this is it's going to be a discussion about salvage law, and in particular, how your salvage claim can be upended, can be sunk by a defense counsel. And there's some things to think about at various stages of a salvage claim, of the life of a salvage claim. And so, as I said, I'm John Fulweiler. I have done this for more than 20 years, which makes me feel rather old. And I've only done maritime law. You know, this office here in Newport, Rhode Island, represents injured sailors and crew on all kinds of vessels, recreational and commercial. And then we also represent a lot of salvage companies in prosecuting salvage claims. And I say salvage companies, but I really should say salvers, because you don't need to be a professional salver to make a salvage claim. If you're listening to this video, please understand I'm offering general information about the maritime law. Do not rely on anything I'm saying here, okay? Every circumstance, every fact can change how the law sees your claim. So it's really important to speak to your own maritime lawyer and understand exactly what remedies you have. This should just give you an overview. It should give you some thoughts and tips. And if you're a professional, you're actually engaged in this business regularly, then it might offer you some considerations moving forward. And you're always welcome to call me at any time. We have two websites which might be pertinent here. One is saltwaterlaw.com, sort of our general website. And then on salvage issues, we own salvageaward.com. We own that URL, salvageaward.com. If you go there, you can put your email address in, and we can send you a kit, a salvage kit, more general information, which you might find helpful. All right, so briefly, I've only practiced maritime law. I used to work in the industry commercially. I still have a merchant mariner credential. I'm looking at the old one where they actually gave you an 8x10 certificate or license. Now they give you a little passport book. But I kind of know what I'm doing in this area, and so you know, I was a partner in a Manhattan maritime law firm for about 12 years, and then I came up here and started my own shop more than 10 years ago, which again makes me feel really old because I've been doing this for some time. But I like it, and it's interesting to me. So that's always helpful. All right, we're just going to click through this, and the way we're going to organize it, and we're organizing it in sort of an analog fashion. You know, there's nothing fancy here. This is just, you know, a way of organizing the three sections. And we're talking about salvage claims, and we're going to talk about the things you could do before a salvage claim, the things you could do during a salvage claim, and the things you can do after a salvage claim, which will upend your claim, which defense counsel will use to say, you know what, I'm going to mess with your claim and sink your claim, and I'm going to end up, and you're going to end up in a situation where you're not getting full value for the claim. You know, a lot of times the salver will feel that the endeavor really is all about that moment of saving a vessel from loss to the sea. But it's not. It's actually a lot of other aspects you know, before and after, which will get you paid for what you did. And that leads us neatly into just a 3-minute synopsis of salvage law, because I think it's important that we understand what salvage is, because it is a unique animal. It's very different from any other concept in the legal world that I'm familiar with. It pays salvage, in broad strokes, pays a person a bounty or a reward for having successfully saved or assisted in saving a vessel from loss to the sea. So you need a couple of things to make a salvage claim. In other words, to have a salvage claim spring up, you have to have a vessel in danger on navigable waters. Don't worry about the last expression. That just means a vessel in danger on your pond is not going to be subject to salvage law, probably because there's no admiralty jurisdiction, and it gets fancy. Just for our purposes, we're talking coastal ocean waters. A vessel has to be in danger, okay? And then you have to have rendered services that were successful, that aided this vessel in some fashion, that helped it in some fashion. And you don't have to be entirely successful. You can, in fact, have rendered services that give you the title of a co-salver, because you could have, for instance, pulled the vessel free from the grounded situation it found itself in, and then another tug came in and moved it along. So you would have a co-salver argument in that situation. These instances you'll rarely hear me, and it might be a good thing for a salver to be thinking this way too, because language is important, particularly in the law, and particularly whether you're before a jury or a judge or in a boardroom before some people you're looking for investment from. The language you use is important. We don't talk about accidents in this office when it comes to the many injury claims in which we represent injured sailors and those families that have lost sailors. We talk about incidents, accidents versus incidents, towing versus salvage. Towing under the maritime law is defined as simply an effort to expedite a vessel's voyage. So in theory, everything else is a salvage. So when you hear me talk about moving vessels off from a grounded situation, it's not towing. I don't use that lexicon if I can avoid it. I don't use that language if I can get around it. I try to use language which talks and which always feeds back to the concept of salvage. I moved the vessel. We tugged the sailboat free from the reef. And you should think that way too, perhaps. So salvage, let's think about this. You have a salvage claim if you have a vessel in danger and if you're successful in whole or in part. And then there's another aspect, meaning it has to be voluntary. That rarely comes up. Voluntary, what the law means in that situation is that you can't have a pre-existing obligation to assist. For instance, think about a yacht crew, okay? Crew aboard a yacht, vessel sinking. The yacht crew has to be careful. There's a line there where it really, at what point can they claim, we're not crew anymore, we're salvers? Well, not really. There is a line there, but for the most part, the yacht crew there is going to be under an obligation to assist as a crew member. So there's sort of a pre-existing obligation to assist. Now, at some point, their efforts will become so great that it no longer falls within the crew concept. But you get my idea. You see this situation with voluntary and harbor tugs. Like some harbor tugs might have contracts to move barges all around. When a barge breaks free and they grab it and move it back to the mooring, can they claim a salvage? Well, the defense counsel will say no. Defense counsel will say, no, not at all, because you had a pre-existing obligation. You were already under contract. So for your purposes, I suspect voluntariness is probably not going to be an issue. Okay, so we've planted our salvage seed. Salvage has sprung up. Well, how high will it get? Meaning, how much value can we get in it? And we now turn to the valuation analysis. And I'm going to use my arm like this, and I'm using this in the way we might use a gauge or a speedometer. Okay, and so you have, typically in these cases, you have a low water to a high water situation. Low water, meaning that it was a pleasant day, maybe on a sandbar in Miami. The vessel wasn't taking on water. There really wasn't a lot of effort. And so that might be a low water. And then you have the dark and stormy night, vessel on a reef, divers in the water. That could be the extreme high water. So you can see how it swings from there. And throughout that swing, you get a modulation of the salvage award, because salvage awards, pure salvage, is based on the value of what you bring back to port. It's called the post-casualty value. Let's back up. We've talked about salvage, all right, what it takes to have a salvage. Now we're pivoting and we're talking about, well, okay, how do you determine the size of my salvage award? How much do I get? And that's based on this low order, high order. Now you'll see you'll see two things that you want to refer to. There are various elements in these two. There's a case called the Blackwall, and in the Blackwall there are Blackwall factors that list things that a court will consider in analyzing the value of the award. Things such as the degree of danger in which the vessel was in, the risk that you as a salver took. And then there's this International Convention on Salvage. It has a lot of the same factors It's called Salcon 89. You can use a search engine of your choice and look up Salcon 89, probably Blackwall too, and read those. And if you're engaged in this as a business, if you're in the business of salvaging vessels, light salvage, commercial salvage, what have you, you should print out Salcon 89 and the Blackwall case and read them, because they are the genesis of salvage in this country. They provide a really good framework for understanding what we're talking about this morning, okay? Now, I don't want to get too far afield, because this isn't me talking about salvage law this morning so much as me talking about how, when you have a salvage claim, it's going to get sunk by defense counsel. In other words, I want to hit a lot of little factors for you to think about. This is the point of this little discussion we're having. It's to think about things that, that maybe you should do differently or do further in your business to help you get the most value, the full value out of your salvage claim. There's an expression I use that partial justice is no justice at all. And I like that expression because I think it's fair. When you make a salvage claim, you get one shot. You don't get to come back and say, hey, I thought of something else. I know you paid me, but I had this other, No, you get one shot at getting it right. So, it's important, particularly if you're in the business, to really focus on getting things right in the beginning, executing the job right, and then afterwards following up, making your claim in a way that will get you all the money that's on the table. All right? So, having said that, I talked about analog, and we definitely have an analog presentation. I actually like using these 3M poster type boards or papers, because it gives you an opportunity to anyway, when I do a deposition in injury or death cases, we will use these and we use them to create exhibits as the witness is talking, and I find it very effective. And we mark it as an exhibit, and the other side jumps around and hollers, and we're in really good position doing that. So anyway, I titled this little talk "Salved," and my idea is, you did the salvage, okay, but you've left some money on the table because you haven't maybe considered all the little things where defense counsel, meaning the counsel is going to represent the insurer or the vessel owner, is going to run in and do all kinds of hooting and hollering and scarfing away at yourself. So before the salvage, and if you're an amateur salver, a lot of this isn't going to apply to you. I mean, it's good to think about, but this is really geared to the professional salver, that entity that might have a towing and salvage business, whether light or heavy. One of the things that irks me, and I'm going to talk about it from the perspective of things that bother me, is before the salvage, you don't have, you have your equipment not working. That is a factor. I mean, how efficient have you been in making sure your equipment works, that your hose connections work, that your hosing works, that it doesn't leak, that things are in, that there's a maintenance schedule, and that you're, and that's really important. You think to yourself, all right, that's pretty self-evident. Yeah, but it's the preventative maintenance that really goes into these claims that really will get you value. Because you know what? You show up and your pump doesn't work, even though you have two more that you get started right away, man, that defense counsel is going to bang on that pot. Bang, 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 they're going to do over and over. Your pump didn't work, did it? And that's going to bring down your claim. You see, they got nothing to work with on the other side except how you fell over your own lacers. Your lacers weren't tied because your pump didn't work. You fell over them, and now, you've got a ding against you. Yeah, they're gonna have some bullets anyway coming at you, but the things you can, don't foul yourself. All right. So preventative maintenance really is the key, and we're going to talk about preventative maintenance in other ways here. Okay, preventative M. I don't have room for maintenance, but you get the idea. Preventative maintenance. All right. Now, contracts. If you're in the business here, you should have two contracts, in my opinion. All right. And I'm just general concept. Your attorney might tell you something different, but I think you should have a salvage contract and a wreck removal contract. A salvage contract, and this gets a little confusing. I have lawyers in cases right now, who are confused on this issue, and I'm not. All right. You can have a salvage contract without destroying a pure salvage claim. A pure salvage claim is the kind of claim you get when you show up and the Bounty, HMS Bounty, is taking on water, and you show up, you get pumps aboard, there's no contract, you just save that vessel. That's a pure salvage claim, okay? So in that situation, if it would not be destroyed if you had turned to Captain Bligh, handed your salvage contract, reviewed it, and had him sign it. As long as your salvage contract doesn't remove the fact that you don't get paid unless you're successful, you still have a pure salvage claim. You can call me if you want to talk about this. I'm happy to review this again because, as I said, I have lawyers who aren't opposing this office, defense counsel, who have this concept wrong. So you can have a pure salvage claim and still have a contract which just sets the outlines, the contours of how this salvage is going to be, how the dispute is going to be resolved, how you're going to get paid. So your salvage contract might say, hey, if we have a dispute, we're going to go to arbitration. If we have a dispute, I get interest. If we have a dispute and I win, I get attorney's fees. All that, does not destroy the pure salvage. If the contract says, I get paid even if your vessel sinks, then you don't have a pure salvage claim. Because the whole concept here is that the pure salvage is that you're risking the concept that you only get an award if you're successful. So you ought to have a salvage contract. You ought to have a maritime lawyer that knows what they're doing, not a maritime lawyer that pulls out the captain's hat and puts it on when you come in the office. You don't want you want someone that does this work. Right? And there are a fair number of us around, but you really want to figure out, are they a member of the Maritime Law Association? What's your client base like? You representing insurance companies? If you represent an insurance company, I'm not sure if that's your lawyer if you're in the salvage business, but that's your call, okay? We don't represent any insurance companies here. Never have, never will. We only prosecute claims. So anyway, you ought to have your salvage contract and you ought to have your wreck removal contract, because there are going to be occasions where you run to the scene and you see the HMS Bounty. And then you realize the HMS Bounty hasn't been worked on in a long time and she's missing a couple of masts. And you might want to think about, do you really want to make a salvage claim in this situation? Because salvage claims are based on the value, as we said earlier, of what you brought back into port. It's based on how successful were you. So if this HMS Bounty is only worth $100, and you bring it back, and after this event it's worth $50, and you bring your $50 HMS Bounty, God darn it, you were successful. You pumped that vessel out and you patched it, and you had divers in the water, and you spent 3 days on it, and you got it back in port. But you've only brought $50 back. On your salvage claim, in theory, the amount you've actually spent, all this, you were looking for $300, but fundamental black letter concept in salvage law is you typically cannot get more than the post-casualty value of what you brought. So your award can't be $300 when all you brought back was $50. So in that situation, many salvers, many of those who are in the salvage business, will look and say, you know what, this is more of a wreck removal situation. I want to guarantee I get paid, even if the thing sinks. And I want to do a time and materials billing. And they do that through the wreck removal contract. So those are the two contracts you ought to have, I think, aboard your vessels. And we're talking about before the salvage, you ought to go through it. You ought to have a program for making sure your staff, the captains that work for you, understand how to complete them, how to fill them out, how to sign them, who should sign them, because you only have, we're going to talk about, I'm getting ahead of myself. That's at the time of salvage. You want to make sure that the right person signs the salvage contract. We'll talk about that in a second. All right. Quickly, I don't want to burn through time. Salvage resume. You ought to have a little Excel spreadsheet. Every salvage you do, you should be recording it so that you can keep a list. That way, 3 years from now, when you get a claim that's very similar to one you've had in the past and they're willing to offer only half, you can say, hey, boys, I got paid X on this, and 3 years later, and inflation, my award should be up here. You get the idea. It's really important. And an inventory of what's aboard your salvage vessels. Okay. I recall there was an ocean rower, and he took a photo recently. It's one of these fellows that rows across the ocean on one of these craft with the two sort of bows, and you sit in the middle and row. And he laid out on the dock next to the vessel vessel might be too big a term. It was more like a dinghy. I got to be honest. It was pretty small. It was you know, I'm not sure I'd row across the Atlantic. At least not today. There are some days perhaps I would do that. But in this case, he had unpacked everything, or maybe hadn't packed it yet, and he had spread the dock so you could see how much goes into the vessel. You should have that with your salvage vessels. You should have an inventory laid out, because then you have a picture and maybe a list of all the equipment. So as a fundamental aspect of what you're doing here, you when you make a claim, you can say, oh, and we use this vessel, and here's the inventory. We're professional salvers, and that's the concept you want to run with. I'm a professional, not a ham and egger. Now, if you're an amateur, I appreciate that. Amateurs can succeed you can get a very large salvage awards under certain circumstances. So there's really, but I'm speaking to the salver who's in the business of making salvage claims. You want to keep that type of resume. Okay, at the time of the salvage. All right, I want to move along here because I'm getting a little further than I wanted to. Okay. If you have open communications with the Coast Guard, okay, the Coast Guard, and I'm not saying this, that they keep logs of things. And so if you're on scene and you've just, and you've pulled up and you've done your initial survey, and you turn to the skipper or the owner and say, looks like it's going to be a salvage, captain, and you want, in my view, you might have a different view, your attorney might have a different view, but in my view, I prefer situations where a salver makes clear the kind of services being provided. So we salvage services, captain or owner, and we're going to be, we're going to be seeking a salvage award, and then you go forward with that. But at that point, if you have time, and there's certain instances where you won't, but you hop back in your vessel, you call the Coast Guard if you've got comms with them, and say, hey, look, we're here next to the HMS Bounty. They've accepted our salvage services. We'll touch back in a moment here. And then the Coast Guard, with some luck, will write accepted salvage services. And the reason this is important is because what happens is that a year later, 6 months later, defense counsel said, they never knew. I'm defense counsel now, and I'm telling you what the defense will be. I never knew, my client never knew it was going to be salvage, and you never told them. Well, what's an indicia? What helps the court think, well, wait a minute, maybe the salver's right. He did tell him, because the Coast Guard said that you called in and said the guys accepted your salvage services. So that's going to help you. All right, so communicate. Remember, the Coast Guard's writing stuff down. Ask them, hey, Coast Guard, can you write this down in your day log? Please note, salvage services were accepted. Okay, another pet peeve of mine that will hurt a salvage claim is letting the owner or passengers assist in the salvage. Now, there are going to be circumstances, and where you're all hands, you need all hands, and that might include the crew and the owner. But that will, in my view, that will hurt your salvage claim some, and keep that in mind. I would not ask casually, hey, owner, hey, skipper, captain, hold the discharge hose in this pump as we move you to a haul out, and have him sitting there holding that. That seems to denigrate, to remove the peril. And maybe that's, maybe it is what it is. I always believe in being absolutely, truthful and accurate, but I also believe in making the best presentation, in being the best advocate for your services. You're a professional. You have a long tail of effort and training and expense that went into being on scene to help that vessel. And so you don't want to have all that effort and expense and training get rubbed away, get sanded away, because you were sort of careless and said, yeah, Cap, hold this. So be leery of that, okay? And then, be another thing that I think salvers sometimes miss is when you get on scene initially, keep looking around. Look around. What is it about the situation? Yeah, the HMS Bounty is on a reef. We get that, okay? That's the danger, no doubt about it. But are there other dangers? Maybe when you get back to your desk after the salvage and you take a beat, maybe you look at the weather and you notice that there's an impending front coming in. Maybe the weather was going to change dramatically. So you see how it's not always, the danger is not always going to be the incident, the grounding. It could be other factors, impending weather. Certain areas in this country have unspent munitions in these target areas where in the mid-Atlantic, where munitions might be located in the flats where they're working. Very dangerous. That would be another element that's going to add to the danger to the vessel and the risk that the salver faces. So don't be, when you get on scene, we're talking about, I didn't change the page here, but we're talking about, considerations when you're on scene, okay, at the time of the salvage. And those considerations, we've gone through a few now, but the one we're talking about now is don't be too tunnel vision. Look around, look at other factors, okay? One of the ones I think has been very helpful, not helpful, but one that I've gotten a lot of traction on in cases is when the crew, when the event has exceeded the crew's capabilities. And you can describe it as the crew is panicked, or the crew, in my experience, sort of just, you become sort of frozen. They're not able to logically flowchart their way through the situation and identify the problem. Pilots have checklists. Most of these vessels don't, and so checklists are there for a reason. It's for when you've lost the starboard engine on a plane. You could go through a checklist. Valves, fuses. And I think vessels sometimes they don't, and the crew and captain will sort of freeze. That's an element that you want to highlight later on. We'll talk about that because it really strengthens the idea that the vessel was in a lot of peril. Because the crew had essentially were unable to face the danger, and meaning that there was really no other option. Your service was invaluable for that reason. Okay. One of the things Defense Counsel will often point out in a flooding situation. Let's go back to the HMS Bounty. She's on a reef and she's flooding. Well, a lot of salvors will stand at the hatch on deck and may take a few photos of the flooding. And this, in itself may be dramatic, but it doesn't really indicate the quantity of water, how far the water is runs along the keel of the vessel, the volume of the water. And so attention should be paid to avoid defense counsels arguing that the water wasn't, what our typical arguments are, it wasn't flooding that badly, it was confined to a single space, and it wasn't as much water in the space that you say it is. So think about that. Stick your arm in it, take a photo, have your crew member photograph it, orient it so that you have a shot showing just how much water there is, and always be thinking, is this limited to this tank space? And if it is, it is. All right. Not every bulkhead is watertight. We can make those arguments later on, and you might when you're on scene be thinking about that. Is water passing through a bulkhead, through the conduit holes, through the other areas of the bilge? And so you could take photos of that. Side note, I'm going to make a side note here. When you take photographs, don't take photos for your lawyer that are all up close or one thing. Photo, close up, orient away. Okay, you've got to give the viewer 6 months later some orientation. You're going to take a bulkhead, take the bulkhead, then take the photo of the electrical conduit with the water coming out. All right. These are simple things, but it's the kind of thing defense counsel, man, they'll just beat that on you. You'll have a problem with that. So remember to avoid that. And then always be asking yourself, how could this danger evolve? Because defense counsel is going to say, they're going to say, so what? Nothing was going to happen. Take out a little water. No big deal. It wasn't going to sink. We had reserve buoyancy. Or, oh, she could have stayed in that reef. The vessel could have stayed in that reef for 3 days. We could have gotten a tug out of Nassau to come and get her. Think about that. Keep thinking when you're on scene, because it's probably the best time to identify how could this evolve. Talked about that bad weather. That might be an indication of how things could evolve. All right. All right, here, we're going to talk about the salvage contract one more time here. Whenever I take a sip of water on video, I always think of Marco Rubio. And this isn't political. This is just a commentary about someone on video. And I don't know if you remember this, and it might date me, but I'd say it was about 10 years ago, maybe less. And Marco Rubio, the senator, had a little water bottle, and he's giving that, I think, like if I recall correctly, a rebuttal comment after it might have been Barack Obama's State of the Union speech. And he's going on, and you talk, you get a dry mouth, and he keeps his eyes laser focused on that camera and tilts over to get his bottle of water and then has a drink over here instead of just taking a drink of water, which I think would have been the way to go. But excuse my divergence there. Anyway, salvage contracts, we talked about them, and I'm just going to mention that when you're on scene, because we're talking at the time of the salvage, make sure you get the salvage contract signed by the captain or the owner, okay? Getting it signed by the captain's girlfriend or some guest that's aboard is going to make things difficult later on to enforce. So just make sure that you're thinking about that when you're on scene, okay? And because I can assure you, defense counsel will be quick to say, it's not enforceable, it wasn't signed by the right person. All right, and we can battle that, and we might be able to get you through that, but if you're trying to get ahead of things, get that signed by the right person. And failing to consider the value, we're all talking again at the time of the salvage, things defense counsel's going to argue, the value of the vessel, the post-casualty value wasn't that great, no big deal. Well, if you're on the bounty, if there's a tender, take a picture of the tender, because the tender's going to be wrapped up in all this. If there's a really elaborate new electronics, take photos of that to help you increase the vessel's value so that we can argue for a higher post-casualty value later on. And I'll do a video sometime on that, on the post-casualty bit and how different courts look at that. But today, just be thinking about, when you're on scene, think about value. How am I going to get value here? Oh, wait a minute, a whole new set of sails, there's a jet ski, make sure we include that. It adds up. Okay. And here's another concept. Don't forget, my last one for at the time of the salvage, don't forget that you're a professional, okay? And professionals, the fire department, let's take a look at the fire department. They're professionals, right? And, they don't roll out to a house fire, with just the police, the fire chief's Suburban and a fire extinguisher, right? I mean, yeah, maybe that the fire chief knows, like, it's just a grease fire on a, a fire extinguisher might not be a good use on a grease fire, but maybe if it's powder, it would be. I forget this lesson. Anyway, my point is this. The fire department rolls out with equipment, not just to treat the immediate incident, but also equipment so that if the incident should evolve, they're ready to go. And I think as a professional salver, you should keep that in mind too. I think you shouldn't, roll out here and then, with the bare minimum. I think you should roll out with what professionally you need to execute the salvage now, and should it evolve in any way, or you could say devolve, meaning getting worse. And I think that this leads me into sort of a sub point on this, and that is, the thing that really defense counsel will just hammer is if you claim a salvage, but you have by your actions not demonstrated that the vessel was in the kind of peril that you are now arguing it's in. So in other words, what I'm saying is that, here's the example. Let's say you have the HMS Bounty. She's aground, okay? And she's aground in a way where you arrive on scene, you do your initial survey, maybe you get your salvage contract signed, and then you're like, there's not a lot I can do right now because of the tide, so I'm out of here for 3 hours. I'll be back 3 hours or in the next tide or something. And that might be fine. That might be the way you roll. But be aware that if you intend a few months later to say, man, the HMS Bounty was in a whole heck of a lot of danger, you're going to have a real problem, because the defense counsel is going to say, oh, was it really? Well, it's surprising then that you went home for 3 hours, and then came back, you left it. And so I think that kind of situation, you should be aware, can be very problematic. And I can tell you, representing for salvers that are professional, that work very hard at being professional, I don't see them engaging that behavior. I see them looking around at the vessel and measuring the kind of things that could go wrong, and trying to take their professionalism to that next step by perhaps, setting float bags or setting an anchor or setting a salvage watch, or slowing vessels that are passing to keep the wakes down so that the vessel structure isn't overly stressed. You see that they're doing things, all right? And again, it goes back to my fire department concept. Yeah, the fire chief knows he might be able to get away with just hopping in the Suburban and doing it this way. But you know what? That's not how they roll, because they're professionals and they show up with all the equipment they need to handle the situation no matter how it evolves or devolves. Okay? That's all I've got well, I've got a lot more for at the time of salvage, but I don't want to belabor this too much. Probably if you're still with me, son of a gun. I appreciate it. And I hope this general information of maritime law is helpful. But again, speak to your own maritime lawyer, okay? Or you call us. If you want to hire us, happy to talk to you about it, okay? But my point is, don't go banging off after watching a YouTube video and my video here and making a claim, say, I got this all set. No, just make sure you speak to your lawyer. Okay, now after the salvage, we talked about three things here. We've talked about some considerations before the salvage, for which defense counsel will jump on. During the salvage, for which defense counsel will jump on. And now we're talking about some things you can do after the salvage, which defense counsel will use to their advantage. And when I say defense counsel, I mean this is the way the system works. I'm not denigrating defense counsel. That's their job. It's not a job I particularly like, but their job is to pick apart, break down and upend your claim, whether you're making a personal injury claim or you're making a salvage claim. So, I just, understand that. And that's why you have to be alert to this. Okay. So after salvage, I think the number one thing you can do after the salvage that will upend your claim and that will leave value on the table is to rush making a written narrative and claim. And I think that's important when you have a salvage, to make a written narrative and a claim, because I think you need to explain what was done, and I think you need to include some photographs and advocate for yourself, and then make a demand appropriate for the situation, meaning demand for a salvage award. And I think that there are instances where, and I'm talking principally to the professional salvers, where insurers will get on the phone, or their surveyors or the adjuster, and they'll say, oh, we got to get that. We're going to get you paid. We're going to get you paid. Give me that report. And you rush your report out, and then they're like, whoa, you want $100? Oh, we were thinking this was a $15 job. Yeah, I'm sorry. And now you've committed yourself to a lot of sloppy facts and a sloppy presentation, maybe included photographs that weren't the best advocacy for you. I see that. I see salvers sometimes putting photographs in that don't really help them. And there's nothing wrong with omission. I mean, obviously if you get into litigation, you want to save those so you can produce them, because the other side is going to want everything. But the idea here is that when you're making a presentation, I would include your best photographs, the photographs that best support your position. So don't rush, okay? Don't rush. And here's another tip for the professional salver. Just because the billionaire owner assures you that he's not going to send this to the insurer, and that if you send it to him, he's going to stroke you a check. Don't worry about it. That never happens. Now, I might be jaundiced because I'm in this office and I always see sort of the claims that didn't work, but I have yet to see in this office, I'm going to repeat that, I have yet to see in this office a situation where a vessel owner just wrote out a check after assuring the salver, don't worry about insurance, I'm just going to write this, because they just don't realize. And I'm not denigrating vessel owners who make that assurance. I think they don't realize how salvage claims are calculated. And they figure it's a time materials charge and what have you. So that goes back to the point that I think it's important when you review a salvage contract that you have a way of reviewing it that sort of gives at least a very brief indice of, hey, this is a salvage claim. It's not going to be time and materials. It's not covered under any of your towing membership plans, et cetera. Now, there may be many instances where you just can't do that. You've got too much going on. You can't do that. Later on, maybe you explain that, and so be it. But be aware that that when we're making a salvage claim after the salvage, take your time. Have a maritime lawyer help you go through it, so that you've got and it leads into my next point here, but you have a good report, and you have a report that makes a demand which is appropriate for what was done. And that means that the salvage award is the right sum. Now, salvage awards are amorphous, right? They kind of swing here. You got my lever I was saying, and different arguments can be made for the value of what was done. And I appreciate that. But you also don't want to be so far out of whack. So you ought to try to get yourself in the realm of, you don't want to be asking for 75% of the vessel value. I mean, unless it's a very low value vessel, there might be situations where that happens, but you get my drift. You want to make sure, or try to be within the realm of where other maritime cases and arbitration awards fall. And so, you might have an outlier because of a particular circumstance. I respect that. But I think that's where the counsel of maybe not your other salvage buddy, so much as a maritime lawyer can really be helpful, particularly one that is engaged in this business on a regular basis. I think that's important. So don't rush your salvage awards. Don't write too much, don't write too little, don't include photographs, don't help your position. Why I get these draft salvage reports, everyone's, the Coast Guard was on scene and then we were on scene and then, I don't know, do you have to mention the Coast Guard was on scene? I mean, it's gonna come out. I mean, I'm not saying not to be truthful and accurate, but unless the Coast Guard did something, the fact they're drifting around offshore, I don't know, does that help? Mention them, and it gives you a sense of how I think you need to be an advocate for your position and be thoughtful, measured, and professional about the reports that you write. And you hire a maritime lawyer, help you with a couple of them, and you'll get the rhythm and the meter and the time of writing these. And I think you'll be able to do them yourself. Time materials rate sheet. I think that's, I think there are pros and cons for having a time materials rate sheet. I think I'm more pro having a time materials rate sheet than I'm not. And you can talk to your maritime lawyer and other salvers about how you can come up with a time materials rate sheet. This is, I think, my final point, maybe document retention, okay? A lot of your staff, or some of your staff may keep their own captain's logs, their own diaries to record their time so that they can, later on renew or upgrade their merchant mariner credential. We had a litigation recently in which, that was, when you have the anticipation of a litigation, you want to collect all the documents, photographs, et cetera, and preserve them. You don't want to have your protocols be such that those are destroyed. And we were in a position where we had done that. But during a deposition, one of the captains, when asked, well, do you keep a logbook in the boat? And my clients were unaware that they did not keep one. The captain said, yeah, I do. And he had kept his own personal one, which then we had to go back and get it and all this thing. But you see, that's a bullet. That's a bullet. It's not a bad bullet, but it's just a bullet. It just drags your claim down a little bit, because he had a notebook, and then you got to, in your head as a lawyer, you think, well, did my client's times match up with those times that he might have recorded there? What's going on here? Because the captain might have recorded a different set of times based on where he was coming from versus other vessels. So it can get, it's just a bullet. Just you want to be aware that with your documents and your photographs, after a meaningful salvage, I would ask that I would encourage you to consider having a program where you collect everyone's iPhone pictures or cell phone pictures, you get everybody's log entries, you get all the vessel log entries, you get maybe your office takes entries, and you get a folder, you put it all in there, all right? Even though you think you're gonna get paid, easy on this one, at least you've got a folder, so if it devolves and 6 months from now you call me, you call another maritime lawyer, you've got all this preserved, and there's not a lot of scrambling. So, I think for our purposes, that's what I have to say. This has been a discussion about salvage, making salvage claims, and how defense counsel may upend your claim, may sink your claim on certain aspects. We could talk about this all day, and I'd like to, but I think this is long enough for this video, and I appreciate your time. And again, my name is John Fulweiler, and I have an office here in Newport, Rhode Island, and you can reach me anytime at 1-800-383-MAYDAY. That's 1-800-383-6293. Or you can go on one of our two websites, saltwaterlaw.com or salvageaward.com. And I'd be happy to hear from you. And if you want our salvage kit, just email us and we'll get you a salvage kit out. And look for some other videos. We've got some on our website. I'm going to make some more about salvage contracts and salvage awards and such. And we'll make them a little shorter than this one, but we'll go from there. So thanks again. Bye-bye.